Okay, well, good afternoon, and welcome to this next in the series of speakers for the second semester. Today we're very pleased to have with us Laurie, the Treasurer of the Law Society of Upper Canada. The Treasurer is the top elected official and head of the Law Society of Upper Canada, or for the province of Ontario, thus the equivalent of our President of the Law Society of Saskatchewan. Treasurer Pawlitza was elected by convocation as the 63rd Treasurer of the Law Society of Upper Canada in June 2010 and elected by acclamation for a second term in June 2011. Treasurer Pawlitza is a partner at Tork & Mains LLP in Toronto and practices in the family law area. She received her law degree from a very distinguished law school, being the University of Saskatchewan, and was thereafter called to the Bar of Ontario. She's a committed advocate with very extensive knowledge in the area of family law and has received a number of awards for her work in that area. She's played an active role in the legal community throughout her career. A few examples being that she served as Director of Law Pro, a member of the Ontario Bar Association Family Law Executive, on the Family Law Rules Committee, but many others as well. She was first elected as a bencher of the Law Society of Upper Canada in 2003, re-elected in 2007 and in 2011, and held a number of high-profile positions as bencher, including leading up a number of significant workforces and task forces in that role. And so we're delighted to have her return today to the University of Saskatchewan and to speak with us on what it's like to be a law profession regulator in 2012.
Thank you very much, Dwight, for your introduction. I also have to thank Dwight for making sure the weather is so fabulous. It's actually much warmer here today than it is in Toronto, so I say to my husband, he can eat his heart out. It's really nice to be back. This is the first time I've been back to the law school since the renos were done, and it looks pretty great. So I think you should be proud. And it's also nice to see a couple of familiar faces in the crowd. And for anybody who wants to know whether or not you can get CPD, the President of the Law Society of Saskatchewan is here, and you can just ask Greg Whalen whether or not you can get CPD for this. I thought that I might start, before I talk about the challenges of self-regulation in our current environment, I thought I might start by just telling you a little bit about the Law Society of Upper Canada. And as Dwight said, the Treasurer is the equivalent of the President of the Law Society. We call ourselves the Treasurer because the Treasurer was the head of the Inns of Court in England, and we've still kept that term. Why we still have Upper Canada is another whole story that takes too much time to go into at the moment. I will say that being Treasurer is an interesting job. The first Treasurer of the Law Society was elected in 1797. And he no longer held that post as of 1801, so he held the post for 4 years. He left the treasurership because he was killed in a duel by a jealous husband, actually. So I'm quite happy to say that that's been the only treasurer thus far that's happened to. My husband's glad too. The Law Society, as I said, was founded in 1797. There were 10 lawyers in Upper Canada that were present, 15 of the 15 lawyers who existed in Upper Canada at the time. We now regulate 43,500 lawyers and about 4,100 independent paralegals. We're actually the only jurisdiction in the world to regulate the providers of all legal services. So that is something that we do and that we've actually only been doing in terms of paralegals since 2006. Our power, of course, to self-regulate comes from our provincial legislation, our Law Society Act, and it confers on us the obligation to regulate lawyers and paralegals in the public interest. Our mandate, of course, includes conduct, competence, and it also requires us to facilitate access to justice. So that's our task, which sounds relatively modest when you can say it that quickly, but it's not so much. We all have, as regulators, all the law societies in Canada have essentially the same mandate, but size-wise, Ontario has the most members. The next largest is Quebec, and after that, BC. I'm going to just give you a few more quick facts about the Law Society, because when I perhaps speak to you about the numbers, some of the regulatory issues that I will talk about are often driven by the extent of our problem. So just to put things in perspective, our Professional Development and Competence Department licenses about between 1,700 and 1,800 new lawyers every year. And every year since we were licensing, since we've begun to license paralegals, we've licensed about 800 paralegals a year. We introduced continuing professional development, 12 hours in 2011. That was our first year. Our penalty for not doing your 12 hours is a summary suspension. Just to put things in perspective, the Law Society last year provided almost 90,000 registrants with CPD programs. And we were expecting, when we budgeted for it, that we would do about 45,000. So as you can imagine, from an operational perspective, we were bursting at the seams. Our budget at the Law Society of Upper Canada is about $90 million. And we have about 550 employees just to regulate the profession and do what we do. On the CPD issue, you might find it interesting that about 33,000 lawyers and paralegals had to do CPD. By February, 961 had not yet completed their 12 hours from 2011. And we have a portal system where you have to go in and register your hours. 194 had not been on the portal. So we're actually moving forward, and this month people are going to now be suspended for not having done their CPD. In terms of our presence, our website gets about 2 million hits a month. So it's a very, very busy website. We have on our website our lawyer and paralegal directory, and that actually has every lawyer and paralegal's discipline history on it, because we want to have a system that is fair and transparent, and so that the public can understand what they're getting when they see a lawyer or paralegal and when they're hiring one. As part of our Access to Justice mandate, we run a legal referral service where we refer people who call to either lawyers or paralegals within their geographic region who will give them a free half-hour consultation. And we get 12,000 calls a month to our legal referral service. That's busy too. Our discipline budget, in terms of our conduct obligation, means that we investigate, well, we get about 7,000 complaints a year. About 5,000 of them are within our jurisdiction as a regulator. Some of them are not within our jurisdiction. And our hearing panels hear about 150 hearings a year. We sit in hearing panels of 3. The hearing panel determines the results and also determines the penalty. And on every hearing panel, we have a lawyer and a layperson, and if it is a paralegal matter, there's a paralegal on the hearing panel as well. We have an internal appeal panel, which sits 5, and there will always be a layperson and and usually a paralegal, and if it's a paralegal matter, always a paralegal on the appeal panel. So those decisions then can be appealed to our or it can be appealed to our divisional court, and then ultimately to the Court of Appeal. So that's the lay of the land at our law society. We are a regulator that is large. And I've been treasurer for just under 2 years. My term is finishing at the end of June. And I thought that I would use that little introduction to tell you a little bit about what I see has been happening with respect to self-regulation both in Canada and elsewhere in the world. I also thought I would perhaps try to give a little bit of context to why the law societies in Canada take steps and sometimes do what they do when we're regulating lawyers, and in our case, when we're regulating paralegals as well. So when we change the rules of professional conduct, when we introduce continuing professional development, when we say we're going to do spot audits, for example, we often, as the regulator, hear an audible groan from the profession. And, you know, I too am a lawyer, and I too practice, and I too have these obligations imposed on me. And sometimes I sigh as well, but there's a reason that we do it. And so I'm going to try to explain to you why it is we do some of the things that we do. So, over the past couple of years that I've been the treasurer, I've actually had a great opportunity. I've been able to meet with the presidents of the Law Society of England and Wales, to the president of the Solicitors Regulation Authority in England, to the presidents of the various law societies in Australia, and the Director General, they call them, as opposed to the president, of the Irish Law Society. And of course, that's of interest to me because in UK, Australia, Wales, and now in Ireland, the legal profession has in large part lost its ability to self-regulate. So I'd like to start today by saying anybody who takes self-regulation for granted is living in the past. I'm going to talk about the pressures and challenges that we've got and to our self-regulation. Talk a little bit about that as far as Canada goes. I will say that in the recent past, I've heard more and more lawyers saying, well, why should we care about self-regulation? What's really the matter with the government regulating the legal profession? And so I'm going to talk about three things that have happened in Canada that I think should make you interested, at least, in why we need to continue our right to self-regulate. The premise, of course, is straightforward. The lawyer is the buffer between the citizen and the state. And for the lawyers to carry out their role properly, we can't be influenced and we can't be interfered with by the state. We need to be able to challenge the government, challenge their legislation. We need to be able to do that on behalf of our clients without interference. And what self-regulation allows us to do, it minimizes the influence and it minimizes the risk of influence on lawyers and, of course, in our world as well, on paralegals. The most tangible feature of our independence is solicitor and client privilege. And I'd ask everybody to remember that only solicitor and client privilege, that is only granted, of course, to the legal profession. No other profession has a privilege that goes to that extent. So you might wonder why I'm so focused about the right to self-regulate, and the answer is pretty simple. The world has changed. So after 9/11, there's been a real concern about terrorist attacks and how terrorists are funded. Technology has vastly changed everything that we do, and consumers are being vociferous and they're demanding answers, and they're demanding answers now. And the worldwide economic crisis has also heightened consumer and government anxiety. So the public now has very different expectations of many things, including their expectations of the legal profession. They communicate that to the government, and the governments respond to public pressure. As I see it, it's really pretty much that simple. So in Canada, there have been three relatively recent incursions on our right to self-regulate that I'm going to touch on. The first is, of course, with respect to money laundering. And I'm going to go back a little bit, but there's also a more recent and connected example. So in 2001, Canada passed anti-money laundering legislation, also known as the Proceeds of Crime (bracket money laundering) close bracket and Terrorist Financing Act. Hence anti-money laundering legislation, because it's just a bit complicated to say that. That legislation required lawyers to report on clients, required them to pass along confidential information about their clients to a government agency, and required that to be reported to the government agency in secret. They couldn't tell their clients. By November 2001, the provincial law societies started litigation against the federal government, arguing that the provisions of the legislation violated solicitor and client privilege and the principle of independence of the bar. And law societies all over the country got interim injunctions that prohibited the federal government from applying the legislation to lawyers. And after much discussion and negotiations with the government, the legislation was actually amended to take lawyers out of it and to remove lawyers from those restrictions. But in the meantime, what happened? The law societies as regulators didn't sit idly by and only challenge the legislation. The Federation of Law Societies, which is the umbrella group for all of the law societies in Canada, of which there are 14. And Justice Daniluk and Greg Whalen can't answer this question, but does anybody know why there are 14 law societies in Canada? Can you count them up? 10 provinces, 2 societies in Quebec, the Barreau and the Chambre, and 3 territorial law societies, 14. I couldn't understand that for the longest time until I realized that there were 2 in Quebec. You see, I'm a born and bred Westerner, really. It's clear. So, the law societies, under the umbrella of the Federation, got busy. And they developed the no cash rule, which meant that lawyers can't accept more than $7,500 of cash. And the rule was adopted by all the law societies in Canada and is now part of the rules of professional conduct of all the law societies. But the government's efforts didn't stop there. And in 2008, another effort was made to bring lawyers within the government's legislative scheme by a Know Your Client regulation. And it required that there would be verification of any transaction of $3,000 or more. It required that lawyers keep records of the transactions, and it required the lawyers to produce the transactions to a government agency. Sounds remarkably similar to the legislation that we successfully avoided the first time. The Federation of Law Societies this time took charge of the litigation and argued it in the BC Supreme Court. But again, during that time, while that legislation was being challenged in the BC Supreme Court, the Federation didn't sit idle. So it developed a model rule, which again has been implemented at all of the law societies, mandating the steps that a lawyer has to take in knowing your client. So the Federation challenged the legislation, as I said, and the BC Supreme Court said, among other things, in finding that the legislation ought not apply to lawyers, that the law societies already provide an effective and constitutional anti-money laundering and terrorist financing regime. So the judge in BC made her finding, in part at least, because of the rules that all the law societies had already adopted. Now, I should say that the federal government has appealed this to the BC Court of Appeal, and the Federation will be responding in the BC Court of Appeal in due course. But we lawyers, resisted an incursion into solicitor and client privilege because the law societies recognized that there was a bona fide need, but we had the opportunity as a regulator to fashion a response to the need that was out there in a way that made sense. It protected the public interest, but it also protected solicitor and client privilege. And that's because we could fashion the response. Now, I'm going to chat a little bit about the Fair Access to Regulated Professions Act, which exists in Ontario and exists in a couple of other provinces. Fair Access to Regulated Professions Act, or FARPA as we call it, scrutinizes the licensing process of all of the regulated professions. So massage therapists, doctors, dentists, architects, engineers, and so on. So it's a one-size-fits-all approach to regulatory bodies. FARPA can advise the minister and recommend to the Law Society and to the minister that our licensing process, our bar admission processes, be changed. And this is one of the reasons in Ontario that we are looking at articling, again for the umpteenth time, as a requirement of our licensing process. So I'm just going to digress for a moment and talk a little bit about articling in Ontario and why we're looking at it. In Ontario, to be admitted to the Ontario Bar, you write 2 exams, each of which are 7 hours in length, a barrister's exam and a solicitor's exam. The exams are multiple choice. And you may think, sounds pretty easy peasy. Well, let me tell you this. Every question has 4 correct answers. So the student's job is to choose the answer that is most correct. And we vet these questions with the profession because we want to make sure that they satisfy entry-level competencies. So this is what's required of a lawyer entering the profession in this particular area of substantive law. And they are exams that then are tested by psychometrists. We have an exam bank. We guard that religiously. And it costs us about $250,000 to develop additional questions for that exam bank every year. So we are very satisfied with the examination part of our licensing process. And I should say, as an aside, that on the first write of those exams, between 15 and 20% of the people fail on the first write. But we also require that everyone go through a 10-month articling process. We currently have 6 law schools in Ontario, a 7th soon to open. And we also in Ontario get approximately a third to about 40% of candidates who have been internationally trained and wish to come to Canada to practice. So they come through the National Committee on Accreditation. So in the last number of years, one of the law schools in Ontario has increased its enrollment by 100 students. And the increase just over the last 3 years from the National Committee on Accreditation and students coming to Ontario to be licensed has gone from 100 students. We're now up over 300 students. So our numbers have been significant, and not surprisingly, suddenly not everyone can get an articling job. So the question is always asked, well, why ought not the market prevail? And the answer is, interestingly enough, because people who are applying for articling jobs and are currently unplaced, and at the moment there's about 250 students unplaced from the current complement, and still some unplaced from the year prior. So we have a number of unplaced students. They tend to be, because we've looked at this carefully, they tend to be mostly students with B averages, so they're good students. And for a variety of reasons, they're not getting articling jobs. In part, the NCA candidates are just coming in out of sync in our system because we have a fairly regimented system about when people get summer student interviews, when they get articling student interviews, and so on. The largest number of jobs that the profession seems to be able to produce is about 1,500, and yet about 1,750 are coming into the system. We attempted in 2008 to create more jobs, entirely unsuccessfully. And as a consequence now, we have people who have, students who have well over $100,000 of debt. Tuition at U of T at the moment at law school is about $25,000 a year. Articling students at the big firms are getting salaries now of about $70,000 a year. They receive excellent training for life in a big firm, but no one is prepared, I think it's safe to say, for what life might be in a smaller firm. And one wonders how we can justify articling when we actually don't assess people's skills after articling. They write examinations, they're tested on substantive law, but what we don't do in Ontario is assess everyone's skills after they have articled. Are they at entry-level competency at that point? And at the current moment, we don't assess that. So we're in this unfortunate situation where we have defensible exams, and then we've devolved to the profession the obligation to create these jobs. There are insufficient number of jobs given the number of candidates, and the candidates all appear to be qualified and are all passing their licensing exams. And so they cannot be licensed because of an articling requirement for which we have no assessment at the end of our skills. And we think, perhaps not the most defensible process. So we are in the throes of addressing the issue of articling, as you can imagine. And for anybody who is remotely interested, you can be one of our 2 million hits a month and go onto the website and look at our consultation report, because we'll be back and we will be passing some changes, I expect, to what we expect for skills training as of convocation in May, so as of our May Benchers meeting. So that's the Fair Access to Regulated Professions Act, because of course the Fairness Commissioner has a great deal of interest in our licensing process. And while she has not yet spoken to us in any detail about the defensibility of our articling process, the Competition Bureau has, within the last 6 years, had a few words to say about the articling process, and has indeed suggested that articling could be conceived or perceived as being a barrier to entry. So as we think about our right to continue to self-regulate, we are looking at the articling process. Why? Because we have, if for no other reason, we have outside pressures that are suggesting to us, or that could suggest to us, that our process is not defensible. And we have to ensure that as a regulator, we have a defensible process. So the last thing I'm going to talk about in terms of Canada's issues is the Agreement on Internal Trade. In 2008, an amendment to the agreement made it clear that qualified workers had to be able to move from one Canadian jurisdiction to another and work in their profession without added testing, retraining, and reassessment. Only 21 of the 51 regulatory bodies out there who were subject to the Agreement on Internal Trade were actually compliant with the agreement when they introduced that amendment. And one of the groups, I'm pleased to say, was the legal profession. And why is that? Because the Federation of Law Societies, the umbrella group of those 14 law societies, had, since 2001, a national mobility agreement that had a way for lawyers to move from province to province and into the territories and to be able to practice their profession. And those rules were compliant with the Agreement on Internal Trade. So, as you can see from those examples, there are incursions into our ability to self-regulate, and we're facing those issues on an increasing basis. But when we are ahead of the curve, we as the regulator actually participate in designing the solution that works for both the public and works for the profession. So we're alive to the fact that we have to be ahead of that curve given what's happened elsewhere. And if we're behind the curve, I'm going to tell you what has happened in other jurisdictions. So, what's happened elsewhere? In England and Wales, they failed in their job, it's fairly clear, to regulate in the public interest. And so in 2004, a white paper was presented to the English Parliament, and the Secretary of State for Constitutional Affairs and the Lord Chancellor said this: "The frontline legal profession bodies generally seek to regulate their members and represent their interests at the same time. This can lead to concerns that they are not putting the interests of consumers first, particularly in the handling of complaints." Now, you might think that that same criticism could be made against the various law societies, but I should tell you, just by contrast to the law societies in Canada, the Law Society of England and Wales at that time had up on its website the following: "The Law Society represents solicitors in England and Wales from negotiating with and lobbying the profession's regulators, government and others, to offering training and advice. We're here to help protect, and promote solicitors across England and Wales. What's missing from that piece? The public. They forgot they were regulating in the public interest. So they were too busy advocating for lawyers. They weren't handling the complaints that were being made about the solicitors. And the result is that the Legal Services Board has been set up. It oversees the Solicitors Regulation Authority. It handles all the legal complaints. The Solicitors Regulation Authority is now governed by a majority of non-lawyers. And to put it mildly, they've redone their Code of Professional Conduct, and it is quite directive. The Code of Professional Conduct for the solicitors now says, you must achieve these outcomes. One is inform clients whether and how the services you provide are regulated and how this affects the protections available to the client. And in doing so, the solicitors are told they must inform clients in writing at the outset of their matter of their right to complain and how complaints can be made. And it also goes on to say they must inform their clients in writing both at the time of engagement and at the conclusion of their right to complain to the legal ombudsman. And you must give the details with respect to how to contact the ombudsman and so on. So let me be clear. Of course, clients have to have the right to complain against their lawyers in an open and transparent complaints process. But the requirement that each law firm and each lawyer has to, in writing, advise the client of the lawyer's complaints procedure twice, when they're retained and when the retainer is finished, suggests to me, at least, that the Solicitors Regulation Authority has created something that is unwieldy and it's onerous, for which non-compliance means discipline. And, one wonders whether or not that is the best and most successful outcome to be achieved. I should also point out that in the UK and Wales, under the new legislation, they are introducing alternative business structures. Law firms can be owned 100% or less by non-lawyers, and it's expected that fairly soon the grocery store chains, they call it Tesco law, will take the quick real estate deals, they'll take the quick estate work, they'll do volume work at a very modest price, and that sole practitioners are going to be put out of business. So that's the UK and Wales experience. In Australia, the Australian experience is not dissimilar. The government has stepped in to deal with complaints, and the Premier and Attorney General of Queensland had this to say about its new regulatory regime. The era of self-regulation by Queensland lawyers will end. The society, this is the Premier speaking, the society has labored under a conflict of interest as both guild and regulator of more than 6,000 solicitors in Queensland. The days of self-regulation by the Queensland Law Society are over because it's clear Queenslanders have no confidence in a system of lawyers judging lawyers. So, as you can glean from that statement, regulation by government is not kinder, gentler regulation, nor is it necessarily something that is going to balance what is practical to do from the lawyer's perspective and still serve the public interest, which has to be served in a meaningful way. So the most recent example of what's happening in the world is in Ireland. And in December 2006, in Ireland, the Competition Authority released a report, said that the current system found unnecessary restrictions on competition within the legal services profession. The Competition Authority recommended that self-regulation be replaced. And at the same time, the Irish economy, of course, was collapsing. So in 2010, when Ireland sought the EU and International Monetary Fund assistance, the government of Ireland entered into a memo of understanding with the EU and the IMF, and it included a commitment to establish an independent regulator of the legal profession. Ireland agreed to implement the recommendations by the end of 2011, so 4 short months ago. The appropriately named Minister of Justice, Shatter, introduced the Legal Services Bill. And at that point in time, he said, it provides for legal transparency for legal provides for transparency for legal costs and greater assistance and protection for the consumers of legal services. Sounds good so far. It also provides an entirely independent dispute resolution mechanism to determine allegations of professional misconduct. Also sounds good so far. It goes on to say, it is a good day for the legal profession as well, because the restrictive practices which inhibit the delivery of legal services are being removed through business models, and anachronistic and unnecessary restrictions derived from regulatory rules which permeate the profession. They are now outlawed. So the new legal services regulator in Ireland is going to have 11 members, majority of whom are going to be lay people. Only 4 of the 11 are going to be lawyers. 1 of the 7 who are appointed by the Minister of Justice is actually an appointment directly from the Minister's office. The Legal Services Regulatory Authority is going to report to the legislature, and members of the Legal Regulation Authority Board can be removed, and I quote, if, in the opinion of government, the member's removal appears to be necessary for the effective performance of the functions of the authority. The authority has to prepare and provide a 3-year strategic plan to the Minister of Justice. And the minister can either approve the plan or amend it. It also requires an annual report to the minister and to each House of Parliament. And the report has to include a discussion of the performance by the Legal Services Authority of its functions and its policies, and it has to provide any specific document or account prepared by it. It creates a new complaints mechanism. Again, the complaints mechanism is 4 lawyers, 7 people appointed by the government. It mirrors much the same structure as the Legal Services Authority. So the threat to the independence of the bar in Ireland hasn't gone unnoticed. The International Bar Association is up in arms. The Irish Human Rights Commission has called for more independence of the Legal Services Regulatory Authority from the government. The Council of European Bar and Law Societies called it a grave threat to the independence of the legal professions in Ireland and a threat to the rule of law. And even the American Bar Association got into the game and said, what is at stake here for the people of Ireland is constitutional democracy. The public should be warned about allowing one man to anoint himself with virtually exclusive authority over the legal profession. So, notwithstanding that, the government has a majority and it's moved to second reading. It's well on its way, that legislation. So, at long last, I conclude by saying, how did this happen? And quite simply, from the outside looking in, I'm delighted that the Irish Law Society and the ABA and the IBA and all of the organizations are standing up and making a lot of noise about the legislation in Ireland. But the reality of it is, they're locking the barn door after the horse has been stolen. They simply did not do a good job of self-regulation. They forgot they were regulators and they thought they were advocates for the profession. They didn't think about the public interest. So that is why the law societies, together with the Federation, try to distinguish between who advocates the profession for the profession. And in our world, that's the Canadian Bar Association. That's their job. Versus the law societies, who may from time to time, assist the profession with advocacy. But at the end of the day, our ultimate responsibility is to govern the profession in the public interest. That's our job. So if we don't meet that legislative mandate, we're going to place ourselves at considerable risk. So we know that sometimes the rules that we place on people are irritating and annoying, but there is a reason why we require CPD. We have to ensure that there's ongoing competence in our profession. There's a reason that we have Know Your Client rules. We have to recognize that there are issues with respect to terrorism and terrorist funding, and there's a bona fide need for the profession to not participate in money laundering. That's why those rules exist. We have to make sure that what we do, though, is meaningful. We have to make sure that our rules are enforced, and that's sometimes why we do things that the profession's not so keen on. So, we've watched what has happened elsewhere. We know why it's happened. And for us to continue to self-regulate in the public interest, we have to stay ahead of the curve. And that's what we're going to do. So thank you.